When you're in need of help, you need experience and talent to fight for you. The educational background and accomplishments of our attorneys are what make Bordas & Bordas a premier law firm. In law, experience and talent are what matter most. Bordas & Bordas, fighting for justice.
Hi, I'm Jamie Bordas. Welcome to the Bordas & Bordas Legal Review. Each week we talk to you about issues affecting our local area, our state, and our nation. This week with me is Chris Regan, my law partner and good friend. Chris, thanks for being here.
Great to be here, Jamie.
This week we're going to be talking about gun rights, and particularly the Second Amendment of the United States Constitution as it pertains to gun rights. Of course, gun rights have been a hot topic recently, particularly in the aftermath of the tragic shooting in Newtown, Connecticut, where the lives of many young children were taken. And we're going to examine the Second Amendment of the United States Constitution and what exactly it says, what it doesn't say, and what the courts have said about the right of people to own guns, to have weapons, and what that's all about. So, Chris, let's start off with just talking about what exactly does the Second Amendment of the United States Constitution say?
Well, Jamie, the Second Amendment says that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that's its original text, but there's more to how that works in today's world than just its original text. The Bill of Rights, the first 10 amendments to the Constitution, was originally envisioned as a restraint on the federal government and had no application to state governments, like the government of Connecticut or West Virginia, until the 14th Amendment was passed after the Civil War. And then the Supreme Court developed a doctrine called the Incorporation Doctrine, through which each of the first 10 amendments to the Constitution was incorporated into the 14th Amendment's guarantee of due process of law. And what that meant is that the First Amendment, having said, for instance, that we have the right to free speech, that then became part of due process of law, which the 14th Amendment says no state shall deprive a person of due process of law. And just a couple of years ago, about 4 years ago now, the United States Supreme Court incorporated the Second Amendment, holding that due process of law under the 14th Amendment requires the right to bear arms, as described in the Second Amendment, to be applied against the states, so that state governments cannot infringe, as the Constitution requires, on the right to bear arms as it will be interpreted by the courts. But there's a lot of interpreting left to do.
Now, Chris, you made a point there that the Bill of Rights, the amendments to the Constitution apply to both the federal government and to states. They don't apply to private companies or citizens or things like that. I mean, for example, if someone works at a private business, they can't say, well, if their boss tells them you can't say a certain thing at work, gosh, I have freedom of speech. I mean, unless that boss is some type of government entity. I mean, a boss can tell you to do what you want to do. That's right.
That's a common misconception that some people have, that the rights we have under the Constitution apply to us against other private entities. They don't. The Bill of Rights and the 14th Amendment restrict only government action. So in terms of a company having a regulation that says you can't carry a gun, or you can't speak in a certain way, or even that you're subject to search, such as drug testing, if those things are imposed by a private corporation, they're not subject to the Bill of Rights, so that they are not required to refrain from infringing on those freedoms. And those things are governed by contractual arrangements. Sometimes they're governed by labor law, but they're not governed by the Bill of Rights.
Now, one of the questions that people may have is, why the Bill of Rights in the first place? I mean, why does our country have a Bill of Rights within the Constitution?
Well, that was a very significant debate that attended the founding of our country, Jamie. I mean, originally there were some people who felt that we shouldn't have a Bill of Rights in the Constitution because it would be interpreted as a limitation on the rights of individual citizens. In other words, if you make up a list of our rights, some people were arguing back in 1776, then that list is going to be all we ever get in terms of freedoms from our government. And they wanted us to have no list of rights, but only a list of defined powers that the government would have, excluding anything else. In other words, to define negatively the space of our rights by allowing the government only to do certain very limited things. But that experiment has kind of gone by the boards with the Commerce Clause interpretations that we've had over the years, and we essentially have an unfettered police power on the part of states and on the part of the federal government that's limited by the described rights that we had in the Bill of Rights. So it turned out to be a pretty good idea.
Now you've talked about interpretations of the Constitution, and of course, when back in the 1700s, the framers of the Constitution and the drafters of the Bill of Rights couldn't envision every particular scenario that may come up over the course of this country's history, leading up even to today. So there are occasions upon which the Constitution and the Bill of Rights do have to be interpreted. How does that work?
Well, I think, quite frankly, it works by a political process. People don't like to admit this, particularly people in law, but our country continues to be governed, though it is a republic, through a democratic process. And the justices we get on the Supreme Court are selected through a political process. Obviously, the Senate plays a tremendous role in that. The president, who is popularly elected through the Electoral College, plays a part in that. And so we get a Supreme Court that reflects the will of the people expressed over a period of time. And they tend to shape the Constitution to fit their preferences and beliefs about the direction this country should go in. In the 1960s, the Supreme Court of the United States took a Texas felony, which was abortion at the time, and turned it into a constitutional right. Now, that represented not a shift in what the Constitution said, but in a shift in the attitudes of society. We've also seen the Supreme Court of the United States take another felony involving homosexual conduct in this country and turn it again into a constitutional right, and to strike down laws of very long standing against that type of conduct. That again didn't reflect a change in what the Constitution said, but a change in how society understood that type of conduct that was reflected in the composition of the court and is now reflected in our law.
Now, when the courts are interpreting this, is it just the Supreme Court of the United States that's going to make constitutional interpretations, or is it done by other courts as well?
No, I mean every court, right down to the lowest municipal court in the United States, is governed by the Constitution. That is the highest law, the law of our land. And so every federal court and every state court and every court below that is required to follow the Constitution.
Now, of course, despite that, if the United States Supreme Court says something interpreting the United States Constitution, those lower courts, whether it be the state courts, the municipal courts, et cetera, they're bound to follow those decisions, correct?
Yeah, that's absolutely right. The federal decisions of the United States Supreme Court are directly binding on lower courts and state courts. Now, lower federal courts don't necessarily have that same power. A decision, for instance, of the courts of appeals for the various circuits that control different groups of states around the country, those decisions are not directly binding on state courts, but they do have tremendous persuasive weight in terms of helping us understand and evolve the law that the Supreme Court of the United States gives us. The Supreme Court only hears about 100 cases a year, and there are a lot more hairs to be split and circumstances that arise, and so all of the courts have to work on, once we get a big decision from the Supreme Court of the United States, figuring out how it's going to apply in literally dozens and hundreds of different contexts, and that's, of course, been going on for many decades.
Well, Chris, let's turn our attention to the Second Amendment, because that's what we're really going to talk about today, which is the right to bear arms. And of course, you gave our viewers here the text of it, but it starts off with a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, it starts off talking about a militia and the right to have a militia and how that being necessary to the security of a free state. How do individual people, it doesn't say anything about individual people having guns for self-protection, for hunting, for anything like that. How is that Second Amendment morphed into the right of individuals to have guns?
Well, that's a good point, Jamie. There are two clauses in the Second Amendment. That Preparatory Clause that says a well-regulated militia being necessary to the security of the free state, and then the Operative Clause that says the right of the people to keep and bear arms shall not be infringed. And the interpretation that we have received from the Supreme Court that was in conflict with what a lot of scholars thought going into the Supreme Court decision in the Heller case several years ago is that the Preparatory Clause is just that. It's just a comment and not a description of the right. So in other words, it could say anything. It could say sunshine being a preferable environment for the playing of golf, the right of the people to keep and bear arms shall not be infringed. They're saying that the Operative Clause, the second clause, is what's important. That the Constitution says that the right shall not be infringed, and therefore it's not defined or restricted to the context of the militia in the Preparatory Clause.
Well, that's interesting, because it is all within one sentence, but that's why we have a Supreme Court to interpret these types of things. But again, we're talking about a document that was drafted back in the 1700s. Has this been something that's been consistently interpreted over time, or has it changed, as you've described earlier, how things can change through the will of the people over time?
Well, I think it's a combination of both. I mean, when the Supreme Court handled the Heller case, they did a great deal of explanation of how the right to keep and bear arms was understood at the time. There was significant personal ownership of guns in the 1700s, at the time the Constitution was adopted, and it was their explanation of their decision that at the time the Second Amendment was enacted, everyone would have understood it to protect a right to own guns personally, to have them outside the militia context, but also in the home, or even to carry them out in the communities that existed. And those justices explained themselves in terms of enforcing a historical right and interpreting the Constitution as it was originally understood. But you know, they didn't say, for example, that the right is restricted to owning musketry or the simple types of rifles that were available at the time. They've interpreted to allow the owning of modern weapons. So there's significant flexibility in those interpretive approaches that the justices bring. And that's where the nature of our court that I was describing earlier comes into play. They don't reflect just what history decided or what the documents say, but they reflect their own beliefs. And those beliefs are what we're putting on the court when we put people and not machines in charge of our judicial system.
Well, and of course, you know, over time, who the Supreme Court justices are change as well. Of course, they're you know, appointed for life, their lifetime appointments, and people can retire or if they pass away, then they're replaced. But you know, the president selects them; they have to be, you know, confirmed by the Senate. But it can have a big effect as well.
Oh, I think that's very significant, Jamie. And we've just had President Obama has been reelected. Supreme Court justices continue to serve for life, and that's an important fact in how our law develops, because people didn't live as long back when we decided that was a good idea. And Supreme Court justices are now serving into their 80s. It's possible for them to serve into their 90s, meaning that someone can sit on the Supreme Court of the United States for 40 years, which was longer than anybody would have been expected to do so back with the life expectancies that we had in the 1700s. So when justices are going to retire and who is going to name their replacements is very significant for how our rights are going to be interpreted.
We need to take a break. When we come back on the Bordis and Bordis Legal Review, we'll continue talking about the Second Amendment as it pertains to the right to own guns, and we'll get into examining that a little bit more as it pertains to some of the recent events. Stay with us.
When you're in need of help, you need experience and talent to fight for you. The educational background and accomplishments of our attorneys are what make Bordis & Bordis a premier law firm. In law, experience and talent are what matter most. Bordis & Bordis, fighting for justice.
Welcome back to the Bordis & Bordis Legal Review. I'm Jamie Bordis. With me here today is Chris Regan, my law partner and attorney. We're talking about the Second Amendment of the United States Constitution and its right to bear arms, particularly in light of the recent tragic shootings in Newtown, Connecticut. And Chris, you know, one of the things that that people haven't they've been focusing on a little bit is that the type of weapons that were used here. I mean, you know, back in the 1700s, when the Constitution, the Bill of Rights were drafted, I mean, there weren't these military-style weapons that could shoot off 30 rounds at a time, and now you have that. I mean, does the Constitution or have the courts provide any guidance as to, or any restrictions on the types of weapons that people can own?
Well, the Supreme Court was pretty careful, Jamie, to say in the Heller decision that the right to bear arms that the court was upholding on that day was not an unlimited one, and that the ownership of firearms by private citizens in the United States could continue to be subject to what was described as reasonable regulations, not only as to the type of weapons that are permitted, but also as to the time and place and manner in which they can be carried. It was made clear that restrictions on taking firearms into government buildings, for example, or into schools, those restrictions would continue to be valid, and that we didn't have a right to bear arms whenever we want, wherever we want, of whatever type that we want.
You've mentioned this Heller decision a couple of times, and that was a case where the District of Columbia was actually attempting to completely ban the ownership of guns anywhere within D.C.
Yes, particularly handguns. They said you could not own a handgun unless you were a police officer anywhere within Washington, D.C., even to keep in your own home. And that was what the Supreme Court struck down in that case. They said that regulation is too broad, too all-encompassing, and therefore infringes on the right to bear arms as the court understood it.
So because the court said that, people in D.C. can have handguns, but are there any types of restrictions on gun ownership that the courts have said are okay?
Yes, I mean, the courts have upheld in a pretty long string of decisions. They've continued to uphold permitting requirements, registration requirements, restrictions on the types of weapons. For instance, that hasn't changed the law that automatic weapons cannot be lawfully purchased or sold in the United States anymore, except under a very narrow exception that exists, as well as laws against certain places where you're not permitted to go with a weapon, such as to a school or a government building. So those regulations have continued to survive scrutiny in the courts even after Heller.
Now, notwithstanding the fact that, of course, in Newtown the weapon was used in a school, it was taken into a school, simply though that type of weapon, I mean, would states be permitted to restrict the ownership of that type of weapon or that has 30 rounds in it for personal use?
I think that the restrictions on high-capacity magazines are very likely to survive scrutiny under the Second Amendment analysis that we have now, Jamie. I mean, there's no reason why, in order to use for basic self-defense purposes or for hunting purposes, a large-capacity magazine, 20, 30 shots, has any need to be possessed. I mean, it's certainly useful for people if they want to do target shooting or certain kinds of quasi-military exercises, but to say I need that gun to hunt or I need that gun to defend my family, that doesn't add up.
Why haven't we seen that? Why haven't we seen states restrict the ownership of weapons such as those?
Well, that's an issue of culture in the United States, Jamie. I mean, we have a big split in this country between folks who have grown up never seeing a firearm in their home or anywhere but on TV, have no contact with them, don't use them, don't learn about them. And then we also have folks who grow up with weapons and firearms all the time, who learn to hunt as young kids, who have parents who own weapons, use them, learn about them, and those people don't relate well to one another. They come from two different backgrounds, and what we have is folks who see guns simply as a tool that they're very used to, don't see any restrictions as being necessary. They see that as an infringement on their freedom, as an infringement on our constitutional rights as Americans, and they see it as foolish, just like restricting the ownership of knives or hammers or cars or anything else that can be used as dangerous. They find it kind of silly. They think that guns are needed. What you need to keep guns safe is to control the person, not the weapon. Whereas other people who don't have any experience with firearms are sort of horrified by even seeing them around. They just think if we could just get rid of these things, we wouldn't have these problems. And as I said, those two groups of people don't interface well. They have different backgrounds, different experiences, and there's a lot of conflict there. And they elect different groups of representatives who go to our legislatures and to our Congress, and they vote against each other. And we have kind of gridlock on that issue. It is extremely difficult to pass any type of gun control legislation almost anywhere in America because of that left-right divide or that conservative-liberal divide or that city folks and country folk divide.
Well, one of the things I find particularly interesting is some of these same folks that say, you can't take away my guns, you're infringing on my freedom, that's my right to have a gun, are the same people who are against things like same-sex marriage, which, they say, no same-sex marriage. They're okay with restricting freedom there, but not when it comes to the guns. How can they mesh those two things, together?
Well, I mean, that's another example of how we are no different than these judges and justices that we put on the Supreme Court. For example, there's been a states' rights movement on the conservative wing of the United States Supreme Court for a long time that includes this gun control case that we talked about. Includes that and also the striking down of certain legislation involving violence against women, other kinds of states' rights decisions that have been made by the Supreme Court. But then along came a case that said states don't have the right to regulate marijuana use in the home or for personal use. And the conservatives who had so strongly defended the states against federal intrusion in the area of gun control, in the area of gay rights, or wanted to, all of a sudden they found that there was plenty of federal power to prevent personal use of marijuana in the home or for medical purposes, and that the states absolutely had that power, and that that the federal government could require that within the states because of its broad police power. So there's a certain amount of flexibility that people have, not so much interpreting the Constitution according to rules, but rather finding an argument that fits their own preferences, and that's what you see in what you were just talking about.
Sure, and like you said, I mean, it's no different with the Supreme Court justices. They're people just like the rest of us,
That's
and
right.
they're going to find case law or historical reasons that the Founding Fathers had for doing various things to support their viewpoint and to come down with the law. And you know, there are 9 justices on the Supreme Court. It requires a majority of 5 in order to reach a decision, and you know, a lot of decisions are 5-4 from our Supreme Court anymore.
That's right. And it makes them subject to change, and it creates instability in our law, because if some of those older justices, like Justice Scalia, he's an older justice, if he should retire, or if Justice Ginsburg should retire, or Justice Breyer should retire, or die, we hope not, but the president who replaces them will be choosing someone who they think lines up with their own preferences. And if that's President Obama, I think we're going to have justices who are more favorable towards gun control. And if that's a Republican who should succeed President Obama, if that happens, that's going to be someone different. And that person could sit for 40 years. And so the Supreme Court lags well behind the rest of the country. All of the justices are much older than you and I, and in some ways their decisions reflect the views of the country that they grew up in, which is not the country you and I are growing up in. I mean, things like gay rights have changed the face of this country just over the past 10 years. And that's a very different world than folks lived in the 40s and 50s when our Supreme Court justices grew up, or some of them.
Now, Chris, we have a few minutes left in today's show, and I want to talk specifically about Newtown. You know, first of all, was the weapon that was used there, was that something that is acceptable to own in the state of Connecticut?
I believe that those firearms were lawfully owned, of course, not by the shooter. They were stolen by the shooter from his mother.
Now, you know, one of the things that a lot of people have said is, well, it's not the guns that hurt people, it's the people that are firing them. It hurts people, and there need to be tighter restrictions on who's gaining control of these guns, whether it be mental health examinations or some other type of restrictions at the time that people obtain gun permits. Of course, in this situation, it wouldn't have necessarily helped because they weren't his guns anyway.
There's that, and then there's been a lot of talk about mental health issues, you know, playing into this, Jamie. But I mean, each individual regulation that you point out, whether it's better mental health screening, the ability to civilly commit people, restrictions on certain types of weapons, no one silver bullet, to use a metaphor that's probably, you know, inappropriate under the circumstances, can solve any of these problems. It's a whole constellation of rules and regulations that we can do to try to suppress these types of incidents. But in a free society, a lunatic is going to find a way to do things that are crazy and frightening and tragic. And I don't think we can pretend that we can ever be perfectly safe or secure. You know, a lot of our founding fathers said that if we wanted to be perfectly secure, we should go to jail because it's perfectly safe there. But you have no freedom.
One of the things, too, is that, you know, no matter what mental health restrictions you put in place, I mean, a person can be perfectly sane and normal at the time that they obtain a weapon, and then, you know, a few years later, you know, have some issues, psychological issues that cause them to not be sane anymore, and they've still got the ownership of the weapon. So I'm not sure there's any perfect solution, but certainly it seems as though there could be some type of effort, or there could be some type of things that could be put in place to at least help the situation to try to prevent these types of things from happening. And I know even our schools are doing things, you know, here locally, even as we speak, to try to prevent these types of things from happening. But you're right, there is no way to completely prevent it from happening. If crazy people want to do crazy things, they're going to find a way to do it. Yeah,
and in a much more benign context, Jamie, I mean, when we talk about the right to drive a car, I mean, it's a cherished right, and we're a car culture too. And eventually people get too old, or their eyesight deteriorates, or they develop physical handicaps that make it dangerous for them to drive a car. And when we impose regulations such as eye tests, hearing tests, and driving tests on older Americans, you have the same reactions. Some people think, hey, you're taking away the right of a person who's been driving for decades. And other people think, well, that's just common sense. If you can't see very well anymore, well enough to drive, you shouldn't be able to. So maybe there is a place for that in the area of firearm ownership, where people are subject to testing or repeated checks to make sure that you're psychologically sound and also competent to handle your firearm, and also that you have the appropriate storage. In other words, that your firearms are locked up.
Well, Chris, thanks for being here today to talk about the Second Amendment of the United States Constitution. I appreciate you being here. We appreciate all of you for being with us today, and certainly our thoughts and prayers continue to remain with the families of the victims of the shootings in Newtown, Connecticut. A very sad circumstance that can hopefully measures can be taken to prevent similar types of things from happening in our country. Thanks for being with us here today on the Bordas and Bordas Legal Review.